All right, thank you, Taryn. I'm excited actually to do this lunch and learn today for INBA. As Taryn mentioned, I'm a current board member. I'm also an attorney here in Spokane. I have my own practice. I'm licensed both here in Washington and in California. California is where I went to law school and started my practice. So I had an opportunity to start out doing entertainment law. So most of that consisted of copyright and trademark infringement cases. I primarily did litigation, but I had opportunities to do some transactional stuff, which would include actually registering the trademarks. However, trademarks have kind of their own special agency. We've got our United States Patent and Trademark Office that covers the registration and also provides a forum for litigation over trademark and patent disputes. So it's kind of a fun area, and it touches on every single business or business person. So everybody who's doing business either has or is using a trademark. So let's get into that. I know Taryn's going to give me an opportunity to share screens. I have just a pretty simple PowerPoint presentation I put together. Let's see here. Yep, it's giving me that option. To start that presentation. So making sure everybody can see what the PowerPoint here that I have up. Awesome. All right, so we've dubbed this Protect Your Best Asset. Reason for that is because the name of your business is definitely going to be your best asset. That is how people are going to find you. So that begs the question, right, of what is a trademark? I put a little graphic up here. A lot of people will see these symbols and not really understand what they mean or how to use them or if they have to use them. So I can definitely quell some fears there, which is you don't have to use these at all. Whether your mark is registered or not registered, you don't have to use them, but they are available for your use. So it's important to know what they mean and how to use them properly, just so you don't come off as, being in the unknown. So a trademark, the easiest way to say it, it's a source identifier. This tells people the source of the product or service that's in the marketplace. So, and a trademark can consist of any word, phrase, symbol, design, or a combination of these things that identifies your good or service. And so with that graphic I placed there, the TM letters indicate that you are using it as a trademark, whatever that word or name or phrase or symbols or design is, for your business. And it means it's not registered. Registration is a federal agency with the United States Patent and Trademark Office. So once you've registered a trademark federally, you get to use, and once it's actually been accepted and you have your full trademark registration, that's what the circle R stands for. It means I have a registered trademark. So the place that I seem to notice this the most, that's prominently displayed and used, are like on kid toys. I don't know why it stands out the most to me on kid toys, but that's where I seem to notice it. You'll see like the circle R. Not every company uses them, but that's one area where if you're paying attention, you'll see. A lot of older trademarks that have been around for a really long time also use these. A lot of times you'll see them for fast food restaurants, beverages. And again, it's because they want to put you on notice. And they want to put their competitors on notice that they have a federally registered trademark. And we'll get into why that matters and how that benefits you. So the word trademark, it can refer to both a trademark, when you think of a trade, and a service mark. So that encompasses both. Trademark is used interchangeably, whether you're using trademark or service marks. So the word trademark can refer to both either or, right? Trademark is used for goods traditionally, and service mark is used for services. So my law firm, I provide legal services. So I would be a service mark. The name of my law firm is very unique and special to me because it's my name. So my name, I've been very non-traditional in the sense of using Natasha L. Hill. Here in Washington, it's PS for Professional Service Corporation. So that is the name of my law firm, is Natasha L. Hill PS. And that is a name I have every bit of confidence that I can use because it is my name. And that is one of the very narrow exceptions to when you can use a trademark that somebody else may also be using that's similar, is if it's actually your legal government registered name already. So that is one thing you always get to use is your name. However, I will give the caveat, you can lose the rights to your name if you use your name as a business and you do business with other folks. There's definitely opportunities where you can lose the right to your own name. And I've seen that with my own clients, unfortunately, and having to, figure out where you go from there when you've a notorious example is fashion designers have lost the rights to their name. They've used their name for their fashion line. One client that I had in particular that I like to mention, because of the folks that he got a dress on a very memorable moment on television. So the client and the fashion line was called Louis Vuitton. I don't expect many folks have heard of Louis Vuitton. You may have heard of him, but you may remember this moment in television history that's been talked about a lot. Music Television Awards, there was Madonna with Christina Aguilera and Britney Spears, and they kissed on stage. And so it was a big deal, right? And as I'm telling the story, I'm realizing how perfect context this is for INBA in terms of sexuality and everything. And it was a great moment for expressing sexuality, right? No spectrum. And so he dressed them. So the clothes they wear in that scene, Louis Vuitton actually was the fashion designer. Well, he brought in some folks to help him build his business, and ultimately he lost the rights to his business and he lost the rights to his name, and he had to redevelop a new clothing line, a new name that he could use. And I remember at the time it was Louvre. I don't know exactly how he spelled it, but again, just an example that I've had working with a client who unfortunately built a great brand, but on the business side of things, ultimately didn't maintain ownership of his own name, which was used for the brand. So again, how important that asset is, and also very important on the ownership of that asset and deciding, do I want to own it personally? Do I want my business to own it? How does that work? Especially if you are doing business with other folks. So going back to the slide we're on here in terms of what a trademark, how it operates, it identifies the source of your goods or services, and it provides legal protection for your brand. And it can help guard against counterfeiting and fraud. And part of the way it does that is by having this federal system. Trademark protections in the United States are limited to the United States. So if you want protection globally, you do have to go to other countries to register. So I'll want to make sure that that's clear. So you're protecting your mark here in the United States by doing a federal registration. And that notice that it gives allows you to pursue protections if somebody's bringing in goods or services, are primarily goods because we're talking counterfeiting, that are similar to yours. I've seen counterfeiting. We've seen counterfeiting a lot when it comes to fashion. So if you're talking about like Coach or Louis Vuitton, things like that, that's a huge problem for them in terms of shipments that come in. So customs at the border. So having a federally registered mark is what allows them to at least have that legal protection and authority to go after folks who are shipping in goods that are counterfeit. So again, a lot of investment of time and money and energy into protecting a trademark for a brand that is notable nationally or worldwide, to make sure that somebody else isn't out there piggybacking, is what we call it, piggybacking off of the goodwill that they've put into their brand. One of the reasons brand names are important and source identifiers are important is because if we go to the store or if we're out shopping, we want to know that what we're purchasing is going to have that consistent quality or the integrity of the brand that we're expecting. One of the things, and you can kind of see in this image here, a couple brands, I'm sure we're all familiar with these. But for example, there's the war between, Coca-Cola and Pepsi, like what's the best cola, right? And so when you go purchase a Coca-Cola, you're expecting a certain flavor. And if it tastes like Pepsi, you'd be really upset, and vice versa, right? So that's part of why source identifying is so important to these brands, is because they want people to have that trust and confidence when they're out shopping in the marketplace, that they're getting that consistent quality, flavor, whether that's a product or a service. The integrity of that brand is what essentially is behind that trademark. That's what builds that goodwill in the trademark that consumers in the marketplace can identify. So that tells us, what a trademark and a service mark is. I think another important thing I get lots of questions on is distinguishing the trademarks from copyrights. So again, trademarks are source identifiers. It's a word, phrase, design, or combination that tells somebody what the source of the goods or service is. A copyright is much different. It's an original work of authorship. The federal copyrights require that work of authorship be affixed in a tangible medium, meaning capable of reproduction. So there are some requirements if you want to get a federal registration on a copyright, but a copyright can exist, common law, state law, just by creation. So can a trademark. So while you can get extra protections with the federal registration because you put people on notice, and that gives you benefits and the ability to do more from a legal standpoint, all of these things are protected just by virtue of being created and being used. So for a trademark, you have to actually use it to actually call it a trademark. You can't just come up with a great idea, like a great name for something, and maybe you write it down, and maybe you even put it on Facebook, maybe you put it in a blog that you're doing, but unless you're making a commercial use, you're actually using it in commerce, you haven't created an actual trademark. So that's what takes something from just a name or an idea or a word or phrase and makes it a trademark. You're using it in commerce. It gives people the ability to purchase something from you, a good or a service. Copyrights, to distinguish again, original work of authorship, you have a right to it as soon as you create it. So our little doodles and drawings can be original works of authorship, and we may never do anything with them, but they're ours and we own them, and somebody else can't take them and go profit off of them. So you'll see here when we talk about copyrights, we're really talking about artistic, literary, intellectually created works, when everything that we consume for entertainment essentially, or even relaxation. So novels, music, software code. How did we get here on Zoom, everybody? Photographs, painting, the gambit of anything creative. So it's really, when you kind of see them next to each other, you get this idea like, oh, okay, a trademark serves this purpose of helping consumers identify the source of their good or service, and it gives businesses a way to create value in the goodwill that they have established in their brands. Copyrights will protect, the actual logo or design or image, but it doesn't identify the source of the good or service. So trademarks protect, the trademark protects from other people using that same or a similar trademark that would be confusingly similar. So think about being in the marketplace and you're out buying soda or cereal or, shopping for your home. Oops, I went too far. Oh no. And you want to make sure that, one of the easy ways, like we were talking about soda, it's like Coca-Cola versus Pepsi. You're not going to confuse them. They're not similar. When generic brands pop up and they create something, especially package-wise, that looks similar with the color scheme and the font style, that starts to get into the territory of something that could be confusingly similar to a consumer in the marketplace. And that's what we're protecting and preventing against. For copyrights, what you're protecting is your exclusive right to, you have this like bundle of copyrights, they call them. You have this right to reproduce, distribute, perform, display, and exploit your work. And somebody else can't take that and take that opportunity away from you. So again, very different in terms of what they protect. Again, if you think about it, trademarks are really protecting the brands from consumers being confused about what they're purchasing. And copyrights are really just protecting somebody's original work and the rights they have in that so that they can benefit from those works. So there's also different types of trademarks. We talk about trademarks, your name of your business being a trademark, but a lot of folks have a design logo, a special form of their trade name or service name that they like to use. And those can change over time as well. So you'll see here, we've got a standard character. That's just really just words, plain text. Doesn't have to be, you're not claiming the right to a specific font style or color or design. And so it's just covering a standard mark. So literally, as I've got down here, Coca-Cola, just the plain words themselves are a trademark. McDonald's, just the plain words itself is a trademark. But then they've got their design special form mark, right? So that includes trademarks that are stylized, have designs or in color, and certain parts of that packaging of that design or logo can be part of the trademark. So Coca-Cola, for example, they do have a trademark when it comes to their font style. So if you were to go use this font style, it's called Coca-Cola, like that's the name. And then they also have protection in the colors that they use on their packaging. So the red and white, for example, is also part of their Coca-Cola trademark for this mark that we're looking at. So it's the font style and the color scheme. Same thing for McDonald's. Those golden arches, we all know they've, hypnotized us since we were children and continue to hypnotize our children into believing that that's a good place to eat food. In moderation, it's fine, right? So we've got McDonald's, we've got both the font style, the placement, the arches, the color scheme with the red, yellow, and white. Those are all elements of that special form trademark that they have. So just if we look at just these logos here, there's already 2 trademarks just in those logos. There's the plain character mark, standard character mark, and there's a special form. And again, they've made variations of these over time. The other thing, and I think this might be my next slide, is looking at what trademarks actually protect and what limitations there are. So your trademark isn't limited to being used on one good or service, but the application that you file has to be for each good or service. So you can only register one mark in one category of goods or services per application. But you can create trademarks from your business name. You can create multiple marks for your business, whether it's a good or service. One of the misconceptions that's out there is that having a trademark, once you have a trademark, that you own that word or phrase and nobody can use it for any purpose whatsoever at all. And that's not correct. As we talk about trademarks, we really are talking about categories of goods or services. And when you register, you get to pick one. So here's an example. If you're doing a retail store, let's say, and in that retail store, you also have your own line of products. So one of your trademarks would be the name of the store. And let's say the name of the store is the same as the line of products that you also are selling in the store. It's just that you have other products in there too. Your trademark for the retail store that sells all these different types of items, let's say it's stationery, like a papyrus or something fun like that, right? That'll get creative juices flowing there. Overpriced stationery. So papyrus is a name of a store, but it's also the name of their card line. So they are going to have registration for the retail store itself, but they're also going to have a registration for cards and stationery and the products that they make. So that would be 2 registrations just for the standard mark. And then they've got that beautiful little hummingbird that's in the middle of their name. That's their special form mark. So that would also be registered both for the retail store because they use it there, as well as on their products that they create and sell in the store. So that's 4 trademarks right there for Papyrus retail store that they can register. And I'm sure that they have, not that I've looked them up specifically. But that's 4 marks just with the standard mark and the special form mark with them having a retail store and a product they sell within that retail store. So that kind of gives you an idea of how that fits that, where you can absolutely have your mark have more than one trademark, and it doesn't have to be limited. But that doesn't mean Papyrus, if I want to start a Papyrus, juice store where I do fresh pressed juices and I've got a nice, beautiful papaya like princess as my logo, well, I might be able to get away with that, right? Papyrus is not in the business of making health juices, cold pressed juices that I'm aware of. So I could use that name potentially for that business. And then I could sell my own line of cold pressed juices. I might sell some other goods. Maybe I do baked goods and things like that. Those are all outside of the categories that I believe Papyrus with the retail store and the stationery products have registered. So again, it doesn't mean nobody can use your name at all for any purpose. They just can't use it in a similar category of goods or services because that would confuse the public. And remember, that's what trademarks are protecting, is that against that confusion, so that you do get the benefit of the goodwill in your brand, and people know that when they buy something with your name on it, that in that category of goods or services, that they are getting what they think they're getting. Another misconception is believing that choosing a trademark that describes your product or service is effective. They're usually not. And usually that's because a lot of other people are using them, or that term or phrase or word is so common that it isn't going to get any protection because people aren't going to be relying on that to identify a source of goods or services. So creative and unique trademarks are more effective and easier to protect. When you pick your name, let me think of I had a good one and I totally blanked on it, but even Lego. So my kids are big into Lego, right? Lego doesn't really I think it means something in German. I'm not sure exactly what it means. Now I'm going to have to look that up. Hey, Brett, can you tell me what Lego means? What Lego means? I think it means play good. I think he's right. I knew he would know. It doesn't mean interlocking bricks, right? If they called this interlocking bricks for kids, that would be descriptive and that wouldn't be a good trademark. But Lego, nobody knew what the heck a Lego was. And now I don't know anybody who isn't familiar with Legos. Either they have them in their home or they've seen the movie. Legos have become one of the best, I think, toys for kids. And both my children, boy and girl, love them. So having something that's non-descriptive is actually much better because it makes it easier for people who are familiar with your goods and services who are looking for them in the marketplace to identify and make sure they got the right thing and not some generic description. If you went to buy a beverage and everything was called soda, that wouldn't really help, right? But if it was Taryn soda, right? I'm not even going to try your last name right now, but if we add her last name and everybody knows exactly that that's the product and we're not going to confuse it. And if somebody comes up with something similar, we're going to know they're infringing. All right, so the next, as we've been talking about goods and services, it's really critical and important that you identify what you have so that you're properly registering it. The United States Patent and Trademark Office, USPTO, is not very forgiving. If you screw up, they will just keep your money and you will try again. So the costs are, significant enough where you want to get it right the first time. And we'll get into why having counsel can really help with that. But first and foremost is we've got to know what we're talking about, right? So thinking about whether you have a good or a service, it can be confusing. Papyrus has both, that example I gave. So when you're thinking about Papyrus, if you're just thinking about the cards you purchase and you didn't even consider the store you bought it in because you might have bought it at a Target or some other retailer, forgetting, okay, I'm buying a good, but they also provide a service as a retail store. So thinking about these questions, what do customers purchase from you? An actual physical product that has your trademark on it, or are they hiring you to perform an activity for them or a service for them? So that's how we distinguish whether or not we have a product or a service. If it's products that they're coming to you for, you've got goods. If it's activities, then you've got a service. So as INBA, we're providing a service here, right? If you join our organization, then you get membership benefits, including attending lunch and learns. So we're providing primarily a service. However, the lunch and learn itself could potentially be considered a product, a good that people are coming to consume. So this is where things get a little sticky and you really want to flush it out and be thinking about it so you can properly identify what it is you have so that you know what you want to register to protect. And again, trademarks can go across goods and services and you could be having both. But for the application process, if you're registering, it's really important to identify which one you're talking about and which one you're actually processing an application for. So why register? I mentioned earlier that, trademarks are protected just by virtue of you using them. You don't have to register them. It's not a requirement. But if you decide to, it can have some good benefits. One of the considerations you want to have for why it would make sense for you to register federally is because you get national protection. So if you're just doing a retail store, a mom and pop shop here locally, you may not be as concerned. But once you're online and you're making sales nationally and you're advertising in different regions, that's where you want to make sure people in those areas are on notice that, hey, this is my goods, my services, this is the source identifier, my trademark that I'm using to identify those. And that's where federal registration becomes really helpful and really important because it gives that public notice to anyone searching for similar trademarks what you own. So if you go to the United States Patent and Trademark Office, it's uspto.gov, really basic. You can go there and it will literally, it's pretty user friendly, the interface. It's a little outdated. It's not super exciting, but it's fine. You can go to their trademark search database. It's called TESS, TESS. I think it's like trademark electronic search something. I'm not sure what the two S's. I forget the acronym. There's so many acronyms. But you can literally go on there and you can search for your mark, the name that you're looking for, to see if there's a mark that's registered. When you do a regular search, you're searching like for an identical mark. But it also lets you do these what's called bullion searches. If you've done some research in academia, legal research, anything like that, they have these like bullion searches where you can do, this word within a certain number or same paragraph or of this word. And so, or you can do a word with multiple endings. And so what that allows you to do is capture marks that would be similar, not just identical, because trademarks can be infringing on another mark, not just by being identical, but also being too similar. So if you change the spelling of a word, that's not going to be enough to make it different. If you add a word in front or behind of it, that may not be enough either. And so it depends, but that is a good place to start. If you're looking up a word or a name and you're seeing clearly that it's being used by someone in the same category of goods or services that you're looking to use it, then you've ran into a problem that if you use that mark, you're going to be infringing someone else's mark. And so you don't want to do that. The legal presumption that you get is that you're the owner of the mark. And so you don't have to go further to prove that. When you're in court, you have to prove everything. So you have to prove how you create, when you created it, to establish that it's yours. So that means that you have to make more allegations, you've got to submit more evidence, and it takes up that much more time and effort just to get that established if you have to prove and defend yourself against somebody infringing your mark. So the legal presumption is the other benefit you get by having a federally registered mark. That gives you some teeth if you do find out people are infringing your mark, to send them a cease and desist letter saying, I've got a federally registered mark, so you got no excuse. You were on notice. You could have went on the USPTO before you started using this and searched it and found me, and contacted me if you really wanted to use it. The reality is we don't want a bunch of marks out there that are the same or similar, because that doesn't help anybody. That's not helping distinguish goods and services in the marketplace for consumers. It also gives you the right to bring a federal trademark infringement case. And so that opens the door to federal court. There's benefits, there's downsides, but there's benefits to being in federal court. And one of those is it moves a little bit faster. So it will scare the other side a little more, because they're going to have to do more work up front, which is going to cost them more money up front. Gives them a little bit more to think about and weigh cost benefit of whether or not they want to stop using the mark or enter into some coexisting agreement, or pay you some damages for having caused you harm. The reality is, if somebody creates a website that's similar to your business and uses a name that's similar and starts directing traffic to their website where they're making sales of goods or services that are similar to yours, you're going to lose business. It's going to cost you money. And so it is important that you protect against that, because you don't want somebody else piggybacking, making money off of what you've invested in. You can also use your registration as a basis for filing in foreign countries. So I mentioned that it's national protection, it's federal, it's here in the United States, but that means you can also take that registration and go worldwide with it. So the Eastern European, the European Union, for example, has their trademark registration process. So it covers like all those countries. So you don't always have to register in each individual country. But again, if you're doing business worldwide, it's important, because people, when we're talking about source identifier, you want to make sure somebody in another country isn't able to rip you off, and then circle back with the internet, right, and take sales away from you. So that is really important if you are doing global work and you've got a presence in other countries, to have that protection there as well. And then again, we talked about being able to use that circle R, which hopefully is a deterrent. Not always. I mean, if somebody's going to do it, they might do it anyway, but it can serve as a deterrent. There's a lot of people who very naively infringe other people's copyrights and trademarks. They just didn't know. And once they know, a lot of times they'll do the right thing and they'll stop. Not always, but a lot of times that happens. So there's a lot of innocent, we call them innocent infringers. They're doing it, but they don't really have the wherewithal and appreciation that what they're doing is violates the law and is actually causing harm. They may think they're copying or doing something similar and it's flattering or mutually beneficial. That may not always be the case, and it just may not be their call to make. And we mentioned counterfeiting too, about registering with customs. If you have a registered mark, you can do that. And that way you can monitor what's coming in from overseas if that's an issue. Primarily that happens, as I mentioned, with like our fashion brands. So there's a lot of time and money and energy that is spent to protect against trademark infringement. And so you can kind of see we're having the registration in place, getting those additional benefits if you're having to go after an infringer can be really beneficial. Oh. All right, that was not the last slide, but it somehow got away from me. All right, so how an attorney can help is the next slide. So most importantly is just having a good understanding, right? So if you don't really know what you're getting into, you don't know that this asset's important, you don't know how to protect it, getting that general advice is always helpful. But I would say the most important thing an attorney can do for you before you decide on your name for your business and start using it is what's called a clearance search. And what that does is it checks to see if there is another mark out there that's the same or would be potentially similar in a confusing way to prevent against any infringement. I've seen many times recently with some friends of mine in good faith, thought this name they came up with was great, shared it with me. They'd already purchased the domain name and domain name was available. So clearly they could use it, right? It was available. They share the name with me. I do a really quick, I didn't even go on the USPTO. I think I started with just a Google search. And I was like, yeah, there's like a couple names that are similar. So one, it gave me the concern that there may be too many names that are similar in the marketplace. And so maybe you can use it, but you're not going to have any good protection. People aren't really going to have something creative and unique. It's going to be more generic and descriptive in that sense. And so it's not really going to serve the purpose of you being able to build up that goodwill and protect it. So they had to go back to the drawing board to figure out a name. They only spent maybe, I don't know what they spent, like 30, 40, maybe $50 with the web domains. But again, it was time lost, money lost, and then going back to the drawing board. So what I had them do is come up with 3 to 5 names that they felt really good about so that we could do some searches on those. And so that trademark clearance search requires you to look in more than one place. So you can look on the USPTO.gov test search system we talked about. So that's the first place to start. Attorneys are the ones who are usually skilled. There's other companies that provide search services as well, but not just attorneys, but I have a really good friend who I kind of go to for any difficult clearance searches because he knows the bullion stuff better than I do, just to rule out if we have any potentially infringing marks. But we also do these Google searches, right? You got to look online and see what's out there. And you don't want to just look for your exact name, but you want to look for variations of that name as well. So if you were planning to do something when it comes to hair type, right? We all have different hair types. This is something that's become really popular in the beauty world, is identifying your hair type so you can get the best, care and products for it. I did have a really close friend of mine. She was one of the first folks to start sharing her hair journey. And she's a Black woman. She has 4C type hair, which is one of the most coily textures out there. And so when she started her journey, she was one of the first people to be using this term 4C. So we found this other company, this other website popped up. I mean, it looked very similar to the layout, color scheme, and it had the 4C in it. And I'll never forget because they claimed that 4C was a popular term that Essence magazine used. And I searched freaking everywhere and I could not find this term being used anywhere. But now it's popular. So a lot of companies will refer to there's, 1 through 4. I think it goes A through C. So you can have 2A, 3, I don't even know what I have. or you can have a combination of these. But these little terms initially, why they had maybe some protection early on when people weren't as familiar, they just started being used a lot. And they're descriptive, right? They describe your hair type. Even though people weren't as familiar, it wasn't like common language. It's now come to a point where it's commonly used in lots of variations. And so it's not a very good way to identify your hair product is by hair type, because you're not going to get good protection in that. It's a description and it's commonly used now. So that would be one thing where you can get an idea of like what's common, what's being used in the marketplace to decide if you're using something that may be too descriptive that you may have thought was somewhat unique. And it can change over time, which is interesting. There are efforts you have to make to protect your trademark so it doesn't become part of just common lingo. There are situations where folks have lost or potentially lost their trademark rights because of the similarity the common use of that term, and them not protecting it and making sure that it was only being used in connection with their product. One of those examples is, sorry, I'm almost blanked there. It's Kleenex, sorry. I was thinking of what they're actually called. So Kleenex was at risk of losing their trademark. We're all familiar with Kleenex facial tissues. How many of us call them facial tissues? Maybe some of us do. Honestly, I probably just call them a tissue. But people the name Kleenex became so commonly familiar, and it was one of the first products on the market of facial tissues that people just started calling all facial tissues Kleenex. Kleenex is like, wait, hold up. We have a certain quality of product. Not everybody's a Kleenex, okay? And we know Puffs is another really popular brand, right? But same idea that we don't walk around calling facial tissue Puffs like, oh, I need my puff to blow my nose. That didn't happen, but Kleenex was one of those that was at risk because it just became such common use that people weren't identifying their facial tissues by what they actually were, the descriptive word of facial tissue, but they were using the trademark of Kleenex. So they had to put some money and effort into really branding their product and making clear and enforcement efforts to make sure they were stopping other companies, or just that reference that if you're not talking about an actual Kleenex, our product, then you can't use that as just common reference to facial tissues, because that would be confusing and potentially infringing to their trademark. So back to how an attorney can help. They'll help you prepare that application properly. I mentioned that when you submit something to the USPTO, they are not forgiving. If you did it wrong, they will reject it and you do not get your money back. There's no second tries. So it's important to make sure you understand how to fill those out properly. And it's not completely self-explanatory when you're on there. If you're using a name, for example, that looks like it could be in reference to a person or a place, you have to disclose whether or not it is. And there's like an extra drop-down menu you got to know to go to. And if you don't do it, they can either reject your application or charge you more. So you do want to make sure that you understand what you need for the application and that you know how to process it properly. And that is something an attorney can help with. In response to your application, you may get what's called an office action. Office actions can be to clarify something in your application so that you can complete the registration, or it can be to attack that whether or not your application or your mark is potentially infringing. So you may get a response back, and that would be substantive. So there may be a technical response that just needs to clarify some things to get your mark registered, or there could be a substantive response from the trademark office that says, hey, we don't think you have the ability to register this because of these other marks that are out there. That's not the end all be all. An attorney is going to be able to assess and advise you on whether or not you should respond further and make an argument as to why your trademark should be registered, or advise you on whether or not maybe there were marks out there that we didn't do a clearance. Let's say there was no clearance search and you went to the trademark attorney after you got the response back and you got this office action you got to deal with. And it's something substantive and you need to know, do I fight this? Do I respond? Do I make an argument back? Which I've seen and done. And a lot of times you get your mark registered. So I always think of the trademark attorneys as finding a reason not to want to register your mark, but they're not always right. And they're operating in this realm of what they know. And so you may be able to shine some light on what they're not considering, what they didn't find, don't know, to make a good argument for why your mark should be registered. And a lot of times people are picking marks that they feel very strongly about, and they know that there could be issues with, and they want to push it through anyway, because if they do get it registered, it means a lot. One example of that would be Apple. So Apple Inc., which we all know as all of our like Mac and Apple technology, our iPhones that I've got here. When they first started using their name, it was after the Beatles, which most folks are familiar with, the famous Beatles, right? The music band. They had their, I think it was Apple Corp was the name of the Beatles. I think it was their music publishing company, if I'm remembering correctly, or it was the name of one of it. I don't know if it was their music publishing company or if it held some other rights or interests for the band. But they had been using that for like 8 years before Apple Inc. came on the scene. And so there was a whole litigation and dispute over whether or not they could coexist, because if you remember, Beatles are music, right? They're doing music, that's their rights there. And Apple's over here doing technology. They're not in music yet. So when Apple decided to venture into music and started iTunes, they actually purchased or licensed the rights to use the Apple trademark in connection with iTunes and in connection with music, because that would have been infringing to what the Beatles already owned. So that's a good example of how you can have a similar name of a trademark, but operating in completely different industries and markets, different goods and services, but then there's a crossover. And you've got to find the piece there, or you've got to find a new name. They found the piece there. And so that's why we do have Apple in our music world everywhere. So so enforcing and maintaining your trademark is something else a trademark attorney can do for you. So if you do find somebody out there who's infringing your mark, what do? Well, you send a cease and desist letter typically. What does that look like? Well, it depends. How egregious is the infringement? Who is the person on the other side? If they're kind of an innocent infringer, sometimes it's about informing them that what they're doing is illegal. If you have that federally registered mark, letting them know and getting that information out there so they can do the right thing. That's been really successful for me as an attorney. Most of the cases I have where we're dealing with somebody who's innocently infringed, they're happy to kind of make amends. Like, let me stop what I'm doing. Let me take it down. I'll change my name. We give them some parameters, a time frame to work with and be reasonable. And so a lot of times they're not really contentious. It's just a matter of taking care of business and making sure somebody's out there isn't out there piggybacking or taking sales away from a client. And then I mentioned the USPTO has their own forum for litigation over trademarks. It's called the Trademark Trial and Appeals Board. So if, for example, somebody is messing with your trademark and they go and register, you can actually attack that registration through the Trademark Trials and Appeals Board. So it's an agency forum for litigation. And that's got its own special rules and requirements and filing procedures and deadlines. And so it's good to have an attorney who's well-versed in that and familiar to make sure that you're following all those procedures and getting through that process as you need to. And then shielding you from fraudulent solicitations. When you do, the other thing is you get a lot of solicitations, especially once you filed your application, of companies out there that will say, hey, we can monitor your trademark, we can do this for you. And you may not need that or want that, but you know how solicitations can be, especially if it's when it's something that you're not too familiar with, but you have some interest there. So you want to be careful. There is a lot. Every time I register a trademark, as the attorney, I get inundated with third-party emails that are there to sell me some additional service or something. And sometimes it's good for the client and they want that kind of monitoring. Usually it's not needed. But again, just having some insight and expertise on someone who can advise you along the way so you can avoid some pitfalls and save money. One of the things I'll say too is that having an attorney help you with a trademark registration, especially that first step of a clearance to make sure the mark you're choosing you can actually use without infringing someone else's mark and get protection for, is hugely important. Could cost you a couple $100 to do that. but it could save you thousands of dollars down the road and help you prevent from somebody taken away from your business. So my last slide I've got here for us before we start questions is, how much is all this going to cost me? And it really depends, but what I put here is some considerations and some price ranges, and also a reminder that attorney fees are always negotiable. So don't be afraid to ask. And some of those considerations I already talked about were the trademark search. That can take a couple hours. It might take 1 to 2 hours, but it could also take several hours, just depending on the mark and the category of goods and services. But what you'll see here is that I've put that, attorney fees vary. I found them to start around $500, because usually just to get an attorney involved, it's usually an hour to 2 hours of their time. I put a range in here of what I'm familiar with here in Spokane in terms of attorneys' hourly rates. I would say range between $225 and $400. Sometimes it depends on the matter. My rates are at $300 an hour, my current rate, but I do have lower rates for certain matters. And I also do this where if you're going to do the plain mark and the logo or the design mark, so if we're doing two and it's the same category of goods or services, I do a reduced rate on a second application or third application, because a lot of that information I've already had to gather. I've had to meet with the client, get everything set up. So that time's been spent and paid for. And it's just a matter of processing another application with similar information. So that's where a little bit of negotiation and the ability for attorneys to offer flat rates, because this is more controlled time versus like litigation where you don't know, if I send a cease and desist and somebody who knows what I'm going to get back, I might get back a big FU. And then now we're looking at potential litigation, right? And then the number of applications, we use the papyrus example to talk about how there could be multiple applications and being aware of what you're registering and how many applications it's going to take for you to cover your needs for trademarks. And so each application starts at $250. That's paid to the USPTO. Those fees can be higher depending on the class of registration you're in. This one is the least expensive, is the $250 process online. It goes up to like $650 or $750, I want to say, for a paper application for certain types of registrations. And so that's, again, something attorneys can advise on, is if you fall outside of this pretty basic, simple, where most folks, especially startups and businesses, are going to fall. And so I also gave you a range of attorney fees here for a flat rate for actually doing the application. And so I've seen people charge between $750 to $1,500. But usually my experience has been that will include a basic clearance search. So they can give you that initial advice of, here's what I see as far as what your marks are and what you should protect. Clearance search to see if there's any infringing marks in the marketplace that you need to be concerned about or that would prevent registration, and then actually processing the application. So again, a couple hours, you can kind of do some math there to figure out how, if you've got multiple applications, multiple marks, the time adds up. But like I said, I will often do, if I do like a $750 flat rate for a simple mark with a basic search, I may then do that second application at $500 flat rate, and maybe even a third application just as a tiered thing. Sometimes, again, I always put it depends, because there are other factors that come into play, and it really can depend on the mark itself. But yeah, this I thought would be really helpful just to give an idea of what we're talking about. If you end up spending $750 to $1,500 to protect a mark, and maybe that gets you more than one application, right? That money is really well spent, because if you are choosing a name that infringes somebody else's mark and you're looking at attorney fees to defend or to deal with infringement allegations, I know I typically start at about a 5-hour retainer, so about $1,500 up front for anything that is potential pre-litigation. And so those costs can add up a whole lot faster and take up a whole lot more money over time. And if you end up in litigation, you're talking tens of thousands, potential 6 figures down the road, if you are actually fully litigating. And so that's where I say, spending a few $100s or $1,000 on protecting this really important asset, your most important asset to your business, your source identifier, is well worth it. So I want to make sure I save some time for questions. I'm sorry, I tend to talk a lot, but wanted to make sure I covered what I could here and giving you guys some good understanding of how trademarks work and why they're so important and how we can protect them.
Natasha, I think you did a great job of all of that. It's really great. We do have a question in the chat right now. It says from Amy, what about patents? Do you patent applications and cases?
So
Do
the
you
cool
do
thing
patent?
about I don't, but the cool thing about patents is that they are kind of their own special intellectual property. So patents are protect inventions and the processes involved in those inventions. And you have to actually take a separate bar to be a patent attorney. You can't just go practice patent law. So you have to actually take a separate bar. That was never anything that I considered, just because I didn't do a lot of I did more litigation than transactional. You can litigate over patents, but you cannot submit a patent registration with as an attorney unless you're a member of the patent bar. It requires that technical background. I believe there's requirements to have some particular math and science education requirements. And so that's why it's really geared toward making sure attorneys who are practicing in that area have the knowledge and understanding that's required.
Great. Yeah, and I would love to hear if anybody else has questions, because I just learned a whole bunch.
Is anybody currently thinking about a trademark that they're using, or oh, you know what I could share, because I don't think it's definitely not like private information, but I'm working with Vanessa Behan. I'm on their board as well, and they don't have their trademark registered. And for them, it's important because they have third parties that donate that want to display like their logo on their website. And just from an integrity standpoint, first of all, you want to make sure they're using the right damn logo. So some of it's also about like control, right? Like it's not that you care that people are using it, but you need to control the manner in which they're using it. Or you don't want somebody like who donated a couple of years ago and hasn't been donating to be using it to show, oh, look who we donate to. And so that's something that I've provided some assistance with so that they can get their trademark registered. But yeah, does anybody have any questions, I guess, particular to any trademarks that they've used or plan to use, or
hey, Natasha, it's Ilea.
Currently in business? Go ahead, Ilea.
I had just put my question in the chat, but my name, can you go over the names again? My name is used by a farming company that I believe was, or organization that was started in the Netherlands, but like, how does that work? Am I allowed to use my name? Can you go over that part again? My son had come in, and so I kind of missed it.
Yeah, no, you're absolutely allowed to use your own name in connection with services. So products are a little bit different, but with services, if you are, and sorry, I'm going to use your comment here in the chat, Alicia. So if you're starting a yoga company and you want to call it Ilea Perry Yoga or Ilea Yoga or Alicia Young Yoga, nobody can stop you. There can be another Alicia Young Yoga. If that's your name and that's the service you provide, it's you. And it can get a little sticky if somebody like federally registers it, and you got to maybe establish like, this is my name, and like you can't stop me from using my name in connection with my services. If somebody's out there using your name in connection with a product, you can't stop them either. Right? And you can't stop somebody else from using your same name in connection with their personal services.
Okay, so then with the image, like how you're talking about the logos, I always spell my name generally with a lowercase I at the beginning, because people never think that it's an I, they think it's an L. And that's this particular company's logo, it looks like. So would I be running into an issue there, perhaps?
There could be issues. That's actually a good question, because you want to distinguish between that standard mark and you're in the special form. If you were to make Ilea look exactly like theirs, even if you're using it on a different product or service, that potentially could be infringing. It may actually fit better into a copyright infringement claim, because remember, if somebody did a logo, that's an original work of authorship. So even if they don't have you fully on trademark, they might. So because the way that something looks or is styled, that can go into both categories. So it could potentially be both. And that's where, even if they're using it in a different category of goods or services, but it looks really similar, that could be potentially infringing as well.
Well, darn it. I guess I will be reaching out to you in a little bit.
Okay. And again, it's good to do, the untrained eye comparison is different than the trained eye comparison. It's the same. I think about listening to music. Like, I don't hear music the way that a musician hears music because I don't play instruments. I don't read music. I don't know notes. And so I can't even describe it in the way that I would need to if I was in a copyright infringement case. We hire experts for that. So when you hear a musicologist talk about the sounds that they hear, and so it is really important that when we're looking at comparisons, that we're doing it from we're thinking about it from an expert standpoint. Because your comparison, Ilea, you may be fine, but you just may have that uncertainty of, I'm really not sure because I know there's other companies out there, they're using my name, they have it styled this way. Can I use my name, especially if it's not a similar good or service? Will my styling matter? Will, the way I design my logo, will that matter? And it matters, but it may not be a big concern. Like, it doesn't mean you can't use the same color, but if you use the same color, the same font, the same shapes, then all of those things in combination could become problematic. But one thing on its own may not. And so that's where, again, having some advice can give you that confidence, like, okay, what I'm doing, I know I'm protected. And if there's an issue, somebody's got my back.
Okay, great. Thank you so much.
For me, it's so great because these are things I just don't think about, and some of the hesitation surrounding starting your own business, no matter how small, center around these beginning steps of really starting to brand and trademark yourself or your business or your product. So it's really helpful and makes everything seem a little bit less scary, I think.
Yeah, absolutely. And don't be afraid to search on your own. When you guys, like I said, if you go to uspto.gov and you just, for sake of curiosity, even start searching, but you'll also see, like I mentioned, that there's multiple ways you can search, and you can kind of see like, oh, okay, you guys could probably figure out a basic search, USPTO, Google online, do some variations of the name. And once you start seeing stuff that's concerning, then I might need another look on this before I move forward. Or it may be enough for you to say, this is more than I even want to deal with. And if there's enough similar marks out there, then it's just not going to be a strong enough mark to protect. You want to pick something that's not just not infringing someone else. You want to pick something that you can protect and build up that goodwill in your brand, because that holds a ton of value. I know folks who have sold their brand name that doesn't come with any, not a whole lot of tangible physical assets, for good sums of money, because the name recognition is there, the goodwill's been established, or they just really picked a great name and somebody else just has to have it. So there's a lot in a name. It's, like I mentioned, your most important asset for your business. And there's a lot of things to consider when it comes to protection.
I love it.
Yeah, this has been fun. I really appreciate all of you here today. Yeah, if you have any other questions, or if you want to reach out, I can put I don't know if my contact information, but I'll put my email here in the chat. And I'd be happy to, consult with any of you if you have further questions.
Great. Thank you so much for your time, everybody, and Natasha, to giving us all this useful information. We really appreciate it.
Looking forward to doing more of these.
Yay. And then just so everybody's aware,
we're back.
I know, I'm so glad we're back, and I appreciate the attendance. And just so everybody on the call knows, next in 2 weeks from now, our next presenters are Dom and Bomb. You can find them on IG. They are a Black-owned, queer-owned, female-owned fashion designers here in Spokane that are also going to be doing tailoring for those of us who want to be able to wear more masculine or feminine clothing that, we want it to fit our bodies no matter what shape we are and what we want to present to the outside world. So they'll be specializing in that, which is really important for our queer and non-queer community combined. So we're really excited to have them.
I'm so excited. They're clients of mine. So
yay. Oh, well, look at that. That's
oh my
awesome.
God. Yeah, I'll be reaching out. I'll be attending that one too. That's really awesome. I've got
I think Heather
I'm really looking
Bowman
forward
is
to
the one
learning
who
more.
told me about them. Yeah, and I've had some really good meetings with them. They're doing some really cool things, and we definitely need to support people like that. But also, Spokane's up and coming. Look at us growing and doing new cool things. Who would have thunk?
And I heard this term more recently, and I'm sure it's a term that's many folks have heard, but we have a great like micro business community here of entrepreneurs and small businesses. And I just love supporting local. So I'm just really excited for Spokane and the growth that I'm seeing. And we've got a great food scene. We've got a good retail scene, not at the mall either. That's not what I mean. You know what I mean? Like there is great places to just go and explore. So I'm excited for us as well.
Okay. Thank you so much. And I will set up, I'll probably post this somehow, some way on social media as soon as I figure out how to do anything with the Zoom recording. So then you guys can pass off to anybody that you mentioned this to, or you hear it come up in conversation. It'd be nice to have it accessible to everybody. So great.
Awesome.
Thank you all so much.
All right.
And have a good rest of your week.
Thanks,
Stay
Natasha.
safe
Yes.
and warm.
Enjoy the rest of your week. You guys stay warm.
Bye, everybody.
Bye.